Hello, and welcome to our Legacy Planning event. This is a multi-generation event presented today by WellSpring Financial. My name is Jeff Bush. I'm going to be presenting today along with two of my colleagues, Steve Jablonski and Shannon LaRosse. And also, today's presentation is co-sponsored by Landis, Huntsberger, Gingrich, and Wyke. And we have Charlotte Huntsberger to give some perspective on estate planning. Our goal at WellSpring Financial is to take all the pieces of your financial puzzle and put them in place. To do so, we utilize a proprietary process that we call the WellSpring formula. It integrates wealth management with risk management, income and tax planning, and philanthropy for successful families, professionals, and business owners. The WellSpring formula is designed to continually adjust and monitor your critical life and financial events to keep your plan on track. Legacy planning is an integral pillar in our success. As I said, Charlotte Huntsberger will be joining us in a little bit, in addition to the three advisors on our team. Just a few disclosures. This presentation today is just provided to general information on the subjects we're going to cover. It's not intended to provide any specific legal or tax advice and cannot be used to avoid tax penalties or to promote, market, or recommend any tax plan or arrangement. Steve and Shannon and I are investment advisor representatives of, and we offer securities through USA Financial Securities. So the agenda for today is Shannon's going to be talking about naming beneficiaries. Then I'm going to come back up and talk about inheriting tax-qualified accounts, inheriting after-tax annuities, and taxation of inherited accounts. Steve's going to be covering life insurance and long-term care. Then as we move into the second part of this, we're going to bring Charlotte up, and she's going to cover wills, trusts, estate creditor protection, and planning ahead.
A little bit about our WellSpring formula. Back in 2019, we hired a consulting team to come in and really coach us on how we could deepen the client relationship for our clients. And first thing they told us is we grabbed a pen and paper and we brainstormed for about a week of what do we do for our clients. So we had our staff, and it was Jeff and myself. We came up with 113 different things that we do for our clients. And that was a lot, but we couldn't fit that all on one piece of paper, so we got it down to what we call our 7 pillars. And the first pillar is wealth management. And when you go out to an advisor, pretty much anybody will manage your money. We are a bit more conservative with our investing, getting our clients to their goals. The next one is risk management. And we use a software called Riskalyze, which really looks at each individual's and how comfortable they are with fluctuation in their investments. And then we have tax planning, and these are things, can we do something for your taxes this year, or can we do something that when we look out in your future, or even your beneficiary's future, can we be proactive in the tax area? Then we have income planning. And people save money all their lives, but then when they get to retirement, a lot of times they have difficulty turning in their assets into retirement income. So we really look at income along with the Social Security. And if we do wealth planning correctly, risk management correctly, tax planning correctly, and income tax planning correctly, then we can have legacy planning. And this is really up to the individuals we're sitting across from, whether it's money to your heirs, whether it's property, whether it's values, or your values and beliefs that you really want to pass on. And charitable giving is, some people give spiritually, some people give just to straight charities. It really depends on what's most important to our clients. Then we have value-added services, and some of these aren't financial. We do a TV show for over 10 years it's called Financially Speaking with Jeff Bush. We do retirement seminars. Jeff and Shannon have both been published. Shannon's latest one is in Barron's. We do different types of seminars, market updates, and then one of them is really called the sounding board. And this is really for our ideal clients. It's a special service that we have for them, where that maybe their friends, family, relatives, loved ones, they may not be certain, or they may be a little jittery about the markets, their planning, and their future. We're always there to act as a sounding board for our clients. Okay. Then when we get to our approach, so the WellSpring approach, first of all, we look at what matters most to our clients. And when we look at that, we look at family, occupation, and recreation. And that is really the why in people's life. So we sit down with people and find out what their goals are, what's important to them, and really what matters. And then, so we have family, which is most people, it's most important to them, their husbands, wives, their kids, their grandchildren. Occupation, there's really three, when we look at occupation, there's really three people that we talk about, that we have here. One is people that are retired. The second is people that have a retirement target date. And then the third set of people are someone is that they just want to make it optional. They're never going to retire, but they know they could. And then the how is the money. And so we have family, occupation, recreations, why, and then the how is the money. And then we come over to the control side, and we could sit here and talk all day about things we can't control, whether it's the government, taxation, some wars, floods, fires. So we won't focus in on that. It's really important to focus in on what we can control. And really there, it's our philosophy. And this really is all-encompassing. So when we look at your retirement picture, it's like a puzzle that we put together. And then planning strategy is, we like to say this is fluid and dynamic. And what I mean by that is when we help somebody in their lives, it's not usually that their life is constant. It's more, they have ups, they have downs, they go sideways. And then really the actual process is the everyday journey along the way to getting to you to retirement. And when you look at this and you look at the control side and you look at what matters and where they come together is where we live, which is the WellSpring formula.
So I would like to kick us off in discussing the topic of legacy planning by starting with some of the basics. So one of the easiest and first things you should do when considering your legacy is making sure that you've assigned beneficiaries to all of your accounts. And you want to keep in mind that there's various types of beneficiaries you can assign. All accounts should have a primary beneficiary. That would be the individual or individuals that would inherit the account should you pass away. You should also consider assigning contingent beneficiaries. So these individuals would inherit these accounts if both you and your primary beneficiary have passed away. And that's an area that a lot of people go wrong in, is they think that they only need to assign a primary beneficiary. Most common, I'll see, a husband or a wife assigning each other as primary beneficiaries, assuming, well, this is who I'd like to inherit my account. What they disregard, however, is the possibility of both of them passing away at the same time. If that's the case, and they didn't have contingent beneficiaries listed, they can ensure that their accounts would go to whom they'd like to pass them. So it's incredibly important to pay attention to listing both primary and contingent beneficiaries. Most accounts will allow you to assign a beneficiary, most investment accounts anyway. There are several types of accounts that will provide that in the account application. Most common are any tax-qualified accounts like 401ks, IRAs, Roth IRAs, 403bs, etc. That is standard as part of the application. There are other accounts where, unfortunately, it is not part of the application process, and it's something that you have to pay attention to, and your advisor as well. So any account that is jointly owned or individually owned but not tax deferred in any way, a lot of times the application doesn't prompt you to list them. So it's important that you make sure that these accounts are indicated as a transfer on death or payable on death. Two different terms, interchangeable for the most part, depending on the type of account that you have. So it's important that if it's possible to assign beneficiaries, you do so. Make sure it's part of the application process. So if you pass and there is no beneficiary listed, well, your assets are going to go through a probate process, and Charlotte's going to get into a little bit more details on that when she gets up to talk to you today. But I wanted to give you an example of a case where a couple were negligent in checking who their beneficiaries were. So in addition to making sure you have beneficiaries, you want to review them once in a while. So there was a New York Post article published about 20 years ago, and it discussed Bruce and Ann Friedman. So they were a couple they were happily married for over 20 years, and Ann had a pretty sizable pension. Her pension was worth over $900,000, and because Bruce was her husband, she assumed that when she passed, the account would go to Bruce. Typically, that would be how it was. However, what Ann didn't realize is that very early on in her job as a school teacher, she obtained that job before her and Bruce were married. So she had listed a few of her family members, including her sister, as primary beneficiaries. Over the years, the company that managed her retirement account changed hands, and the beneficiary listing was no longer on her statements. So rather than verifying who was her beneficiary or who would inherit the accounts, Ann just made assumptions. So Ann unfortunately passed away prematurely, leaving Bruce behind as her widower. Bruce also assumed that he was going to be entitled to this pension. In fact, he relied on that to fund the rest of his retirement. However, when Ann did pass, they looked at the details, the historical details of her account, and found that she had actually listed somebody other than Bruce. So because of that, Bruce was completely disinherited from this pension. And instead, Ann had a single living relative who was named beneficiary, her sister. So her sister inherited over $900,000, and Bruce got nothing. So I just want this to be a warning to all of you and a reminder to make sure all of your accounts have listed beneficiaries and to verify them occasionally as well.
Inheriting tax qualified accounts. This is such an integral part of the planning process that we do because inheriting a tax qualified account is very different than what happens with assets that are passing through a will. So the first topic that I want to cover is spousal continuation. This happens when you're inheriting an IRA from a spouse. IRS regulations are such that when you inherit an IRA from a spouse, it's just as if the IRA were yours. So with spousal continuation, you simply retitle the IRA into your account, and you're now complying with whatever rules are in place, specifically a required minimum distribution, which occurs beginning at age 73. The other significance about spousal continuation is that all of the IRA benefits that were inherent in the account of the person who died are now the benefits that carry over to the person who inherited the IRA. But it's extremely important to name your spouse as the primary beneficiary on that IRA account. Next, I want to talk about non-spousal inherited accounts. Typically, this is when an IRA account goes to a child. So there is no spouse, so you're naming a child or someone else as a beneficiary. These rules recently changed through the Secure Act that was passed back in 2019. What happens when you inherit an IRA from a non-spouse is you have to follow what's commonly known as the 10-year rule. So with the 10-year rule, you're taking minimum distributions from the account during the 10-year period, and by the end of 10 years, the account has to be completely emptied and distributed to the beneficiary, and all the taxes need to be paid. Next, I'd like to talk about the elimination of the stretch IRA, because before the Secure Act of 2019, if you were inheriting an IRA from a non-spouse, say you were inheriting an IRA from your parent, you could stretch those payments, and we used to call those stretch IRAs. You could stretch those payments over your lifetime. So if you're 50 and you're inheriting an IRA from your parents, you could stretch that out over your lifetime, say 35 years. We can no longer do that. Now we have to fall under the 10-year guideline. Next, I want to talk about inherited IRA RMDs, and that is, when we use the term RMD, we're referring to the required minimum distribution. That's the IRS requirement that you have to take a minimum distribution. So when you inherit an IRA, whether you're inheriting an IRA as a spouse or you're inheriting an IRA as a non-spouse, we have to be mindful of the required minimum distribution. So if you're inheriting a spousal IRA and you're of the age of 73 or older, you have to take a required minimum distribution. If you're inheriting an IRA from a non-spouse, it doesn't matter what age you are, you have to take those minimum distributions. And again, the account has to be fully liquidated and distributed in that 10-year time frame. Next, I want to spend some time talking about the non-qualified stretch annuity. So inheriting annuities are different than inheriting an account that is not an annuity, say a brokerage account or a bank account. With a non-qualified, or when I say non-qualified, I mean like a non-IRA. When you inherit an annuity, you can still stretch those payments over your lifetime. So for example, let's say you're 57 years old and you inherit a non-qualified annuity, you have a life expectancy of 30 years. So you can stretch those annuity payments and the tax obligation over that 30-year period. So this is a very valuable planning tool because we want to be mindful of the tax obligations that you have when you inherit these accounts. One of the little-known facts with annuities are what we call predetermined or pre-selected death benefit options. That's where you can determine while you're still alive how the beneficiary takes their benefit, their inherited benefit. So let's say you have a child that you're concerned about how they handle money. You can put right on the annuity application that when they are to receive their benefit, that they can take it over a select period of time. You could say, I want my child to get this payment over, let's say, 25 years. You want to put them on the installment plan because you don't necessarily trust them to get a lump sum and be responsible with the money. So that's a lot of work that you can preclude some legal work by just simply putting in a predetermined or a pre-selected death benefit option. Federal estate tax. So currently, the annual exclusion is $13.99 million per individual estate. If you have an estate that's that size or less, it will not be subject to federal estate taxes. Now, that does not mean it's not going to be subject to other taxes. So, for example, if you're here in the state of Pennsylvania, you have to file a Pennsylvania inheritance tax return. And if you're a lineal descendant, you're going to be paying taxes at a rate of 4.5%. Also, this does not eliminate the need to pay income taxes if you are inheriting an IRA account where taxes are due, or even if it's an annuity that has gains inside the annuity, you're going to be paying income taxes on the gains. Okay, so again, I want to clarify with state inheritance taxes. For lineal or direct descendants, the tax rate is 4.5%. If you're transferring the assets to siblings, brothers or sisters are paying a rate of 12%. And most other transfers, which are not to lineal descendants or other family members, the tax rate is 15%. How are distributions taxed? So we have different types of accounts that you're going to inherit. There could be a traditional IRA or a 401k or a 403b, etc. We have Roth accounts, we have non-qualified annuities, and then we have what we call after-tax accounts, which would include brokerage accounts or bank accounts. So with a traditional IRA, taxes have not yet been paid. So that means that the person inheriting the IRA is going to be liable to pay the tax. With a Roth account is considered after-tax money. So when you inherit a Roth account, there is no tax liability because the tax liability has already been paid. With a non-qualified annuity, you're going to be inheriting a combination of cost basis and taxable gains. So you're going to be paying tax on the taxable gains, but the cost basis that you're inheriting will be transferred to you without tax. And then, of course, after-tax accounts, so let's say you're inheriting a bank account or a brokerage account. Generally speaking, those accounts are going to be coming to you in the form of inheritance without any tax that's due. So now we want to look at the history of tax rates. And we've been paying income taxes in this country since 1913. So for about 110 years, we've been paying tax. And when taxes were first introduced in this country, the tax rate was pretty low. It was less than 10%. And even now, as we talk about this today, our top tax bracket is 37%. So if we look at the way taxes were paid maybe 50 years ago, we had top tax rates of as high as 90%. So tax rates have come down significant, and I know nobody likes to pay tax, and one of our roles here at WellSpring Financial is to minimize your tax liability. Still, the reality of the tax situation as it stands today is we have a top tax rate of 37%.
Now, moving on to types of insurance, the first one we have life insurance. And there's two categories here. One is term and the other is permanent. And we look at term insurance. It's basically leasing an apartment, and permanent is like buying a home. But there can be a whole bunch of bells and whistles on top of those, which we won't get into today. And then we have several different purposes of life insurance. The first one we all know, there's a death benefit. The second one is that now we can put on top of a life insurance a long-term care policy, and the benefits can be used, the coverage can be used for either or. We have tax-free income distributions, and this is something at death that the distributions would be tax-free to your heirs. And a lot of times what we see for the last one is legacy planning, is we have clients that do not need their required minimum distributions to live on, so they will leverage that dollar amount into an insurance policy for legacy planning. When we move on to long-term care, here's some statistics here that someone turning the age of 65 today has almost a 70% chance of needing some type of long-term care insurance. And we want to talk about the length of the care. Women average about 3.7% and men about 2.2%. And then this stat is a little eye-opening in that about 20%, or 1 out of 5 people 65 or old will need long-term care coverage for more than 5 years. And with the trend, actually since we've all been in the business, is a lot more people need the long-term care care, I should say. And the supply now is, actually, I'm going to go back. The demand now, with all the people turning 65 and getting older, is more than the supply. So the cost is a $222,000 now, and if it averages, it's actually said it's supposed to go up 5% a year, and then in 2030, it would actually be almost $300,000. So as you can see there, that is going up quite rapidly. And we want to look at who will care for you and who will cover the cost. And there's a couple different options here. The first one is just to self-insure. The pro of that is you know where you're going to get the care. The con in that is that it can be very, very costly and eat up your nest egg. The next one is having your family take care of you, and you know who's going to take care of you. The pros, it's less costly, but the problem here is this can be very, very emotional or a financial drain on the family or the spouse that's doing the care. Third one is you can transfer it to government, and you're transferring now the costs away from you personally. The con is you do have to spend, in some cases, you have to spend down your assets to actually qualify to get into a government facility. And then the last one is another transfer, but this is actually transferring it to a third party through long-term care. So the risk is transferred to an insurance company. You protect your investment portfolio. And the con in this is that two things. One, you may never use it. And the second thing, it is a very much added expense to your budget. Now what I'd like to do is introduce the expert on this field, Charlotte Huntsberger, and she got her JD from Temple. She has served on several boards, and she actually has 3 children. I have known Charlotte for over 10 years, and I'll bring her on, and we'll go from there.
Hello, my name is Charlotte Huntsberger, as was noted, and I'm here to share a few things about estate planning, wills, trust, those types of things. So first thing we want to talk about is the importance of having a will. The goal of having a will is to make sure that your wishes are communicated to your family, and so that whatever you want to make sure happens in terms of your estate plan can happen. It decides how your assets are being dispersed and divided to your beneficiaries. It designates persons that you want to appoint as executors. It allows you to decide who's going to be a guardian of a minor child or trustee of a trust you might want to create. Wills and your estate plan overall should be reviewed every 3 to 5 years and just changed as needed, as your circumstances change, as life change, as your assets change. We also want to talk a little bit about trusts, and we'll get deeper into some of these things as well. Just to have some definitions on hand, trusts come in various forms. A revocable trust would act as a will substitute. There is a common misconception out there that everybody should have a trust, and in some states that is accurate. But in Pennsylvania, Pennsylvania does not have a system which would allow for trusts to be exempt from Pennsylvania inheritance tax. So in Pennsylvania, a trust would not save inheritance tax, and that is how, when people think of tax planning, they hear the word trust, but that doesn't work in Pennsylvania. There are some instances where it's helpful to have a trust. You could have trusts that are set up for specific purposes, owning real estate, giving gifts to children. But revocable trusts in Pennsylvania are not real popular. We talked a little bit previously about the tax liability that persons would incur in handling Pennsylvania estate taxes. And for Pennsylvania inheritance tax, that's taxed on all of the assets. So whether it's in trust, whether it's passing under a will, whether it's passing by way of a beneficiary designation, it's all taxable. There are other types of trusts that you can set up to move assets out of your estate, and these would be irrevocable trusts, trusts that you can't change once you have set them up. These could be an irrevocable life insurance trust, they could be generation skipping trusts, they could be charitable remainder trusts. There's various types of trusts that you could look at in this instance. Another type would be a special needs trust. If you have a child or a beneficiary who has disabilities or is receiving government benefits, you may want to consider having a special needs trust to protect that money from being treated as an available resource before they would qualify for benefits. There's also various techniques that are used in planning if you are in a federally taxable estate, whether that be an intentionally defective grantor trust, whether that be charitable trusts. There's a variety of different types. Most common for most of my clients would be a trust that you are setting up through your will, through your estate planning. And this would be a trust that's created under the will either for a spouse, if it's a marital or credit shelter trust, or it could be for a grandchild because they're young and you don't want them having access to the funds until they reach a more mature age. All of these options are things that your estate planner can help you figure out what is going to be most beneficial for your situation, given your beneficiaries and your assets. In terms of the federal estate tax, right now that exemption amount in 2025 is $13.99 million, as was noted previously. But what you do need to be aware of is if the law does not change between now and the end of the year, that exemption amount will automatically drop in half. So this is the type of thing that you do need to consult with your attorney or your financial advisor, your accountant, to determine, as you're doing your planning, what is the current federal exemption amount. Now, in terms of dealing with an estate, let me just talk about a few factors that become very important in handling estates. When an estate is probated, the executor has the responsibility to gather all the assets and to determine what liabilities there might be in an estate. Understand that debts that are incurred by an individual during their lifetime would be paid by the estate after their death. However, you also need to be aware that the executor is not personally liable for debts of the decedent. So if there's a situation where an individual has passed away and they have liabilities that exceed the value of their assets, that executor is not going to be personally liable, and there is a hierarchy of how those debts would be repaid. And in some instances, it does lead to dismissal of those debts because there's not enough funds to pay it. One thing that you do need to pay attention to as you're doing your estate planning is the need to look at liquidity in planning. We talked before about beneficiary designations and tax liabilities. In a situation when somebody passes away and there's inheritance tax that will be due, the question becomes, how does that get paid? The easiest way to do that is to have that paid through the estate. And one piece of planning is to pay very close attention to what assets are going to pass through your will and what assets are going to pass outside of your will. All of the assets are going to be taxable for Pennsylvania inheritance tax purposes, with the exception of life insurance, which is not taxable. But if there's not sufficient funds coming through the estate to pay the tax liability, beneficiaries may have to pay that on their own. One option, if you want to ensure that there are sufficient funds in an estate to cover the tax liability, is to look at an irrevocable life insurance trust that would provide for a life insurance policy to add liquidity to your estate plan to make sure that there is sufficient funds to pay the tax without the beneficiaries needing to liquidate assets that they otherwise might want to keep. Another thing to keep in mind is if you are at or near a federal taxable estate level, you need to do some planning to make sure that you manage your assets to either avoid the federal estate tax or to look at potentially gifting to family members during your lifetime. Just like the federal exemption amount, lifetime gifts, there's an exemption amount. And for 2025, the annual gift exclusion amount is $19,000. You can gift $19,000 per year per person without needing to file a gift tax return. That's exempt. That amount changes every year, so again, check with your financial advisor, your attorney, your accountant, check with your advisors to see what the current numbers are. There are a few areas that you also want to pay attention to in determining planning that needs to be done during your lifetime. There is 2 documents that I like to make sure that clients have in place that govern things that happen while we're alive. So a power of attorney would be effective during your lifetime, and it appoints somebody else to act as your agent. This person has the legal authority to act on your behalf to handle financial matters if you're incapacitated. Another document that you'll want to think through is healthcare power of attorney and living will. We talked about the lifetime giving. We talked about paying attention to how beneficiaries are designated or joint ownership. Think of it this way. When you pass away, your assets are going to pass to your beneficiaries in 3 different ways. So there are assets that you own jointly with somebody else, and those are going to pass automatically to that joint owner. There's assets that you have designated a beneficiary, and those are going to pass automatically to that beneficiary named. The will handles everything else. So as you do your planning, all of these pieces need to be reviewed to make sure that the plan is going to happen the way you want it to. The other type of planning that you need to do during your lifetime is to determine whether or not you have any interest in doing charitable giving. And there are a variety of ways to do this, whether it's a donor-advised funds, where you donate appreciated assets so that you can avoid the capital gains that would otherwise be used, and use those funds in a donor-advised funds to then complete any charitable gifts that you would like to do. You can also use retirement assets for charitable giving by designating a beneficiary, designating a charity as the recipient of required minimum distributions. When it comes to medical planning, there are things that you need to have in place during your lifetime. This would be a health care power of attorney that authorizes an agent to act on your behalf and make medical decisions for you, as well as a living will. A living will says if I am in an end-stage medical condition or permanently unconscious, then I do not want any life-prolonging procedures. I might want to be kept comfortable with pain-relieving medication, but nothing else. Now, what happens if you don't have a living will? There are provisions in the law that would allow a close relative with 2 physicians consenting to remove a person from life support. But my opinion is it is better for you to be able to express your own wishes in a living will and appoint the person that you want making that decision. These documents, whether it be a living will, a power of attorney, or a will, can be revised and revoked at any point so that you can make changes as your life changes. At the end of the day, the bottom line is estate planning is not a once and done event. It is something that you need to continue to review and revise as tax laws change, as your assets change, and as your family changes. Thank you for your time.
Thank you, Charlotte, for that presentation. That was very insightful, very informative. It's always good to get some legal insight into all these planning issues that we have here at WellSpring Financial. This presentation today is really designed for our clients and their families to really facilitate the discussion and the importance of legacy planning. Thank you. This is Jeff Bush, WellSpring Financial.